Welcome everyone to this EU Settlement Scheme training on working with older people. I'm Bella, Joint CEO of Here for Good, and I'm also an immigration lawyer.
And I'm Carla, I'm Here for Good volunteer coordinator, and I'm also an immigration lawyer based at Bindmans LLP.
So firstly, an introduction to Here for Good. For those of you who do not know, Here for Good is a legal charity which exists to provide free immigration advice to EU, EEA and Swiss citizens and their family members living in the UK. We primarily assist those most in need of free immigration advice, such as the elderly, the homeless, victims of domestic violence and trafficking, people with complex needs and people in financial hardship. Our services include an email and telephone advice line, complex casework done by our members of staff, and we also have a network of volunteer lawyers who are taking on complex cases pro bono across the UK. And an introduction to this training programme. This training is commissioned by the Greater London Authority and delivered by Here for Good. We are conducting 16 EU Settlement Scheme training sessions between June and October 2020. These include this older people training, as well as other specific trainings, and also an overview of complex cases training. The training is designed for EUSS Level 1 advisors, EUSS Level 2 or 3 advisors who do not regularly advise on the EU settlement scheme, and individuals providing frontline support to vulnerable persons. It's worth noting that this training is not designed to replace the EUSS official training, and also that Carla and I are experts in immigration law, but not experts in immigration regulation. If you are EUSS accredited and therefore unsure of what work you should do at your level, we would recommend contacting EUSS directly. The contact details of EUSS and other regulators are provided in our training manual, which will be sent to you at the end of this session. I'm now going to pass you on to Carla, who will discuss the training objectives.
Thank you, Bella. So the aim of this training session today are three aims, basically. One is provide you with an overview of the main issues you might encounter when assisting older people to apply under the EU settlement scheme. Secondly, we will provide you with practical tips in order to best support older people with their applications under the scheme. And finally, we will also raise your awareness about other potential application routes open for older people as well as British citizenship. The structure of the training will be as follows. First, we will provide you a brief overview of the EU settlement scheme. We will then discuss the common issues that arise in cases involving older applicants. We will, as explained, raise your awareness of other application routes open to older people as well as British citizenship. We will then go together through some case studies. And finally, we will have a Q&A session at the end.
So before we go into the main section of this training, we're just going to give you a very brief overview of the EU settlement scheme. If you feel that you need a more in-depth overview on the basics of the scheme, this is set out in a lot of detail in sections 1 to 3 of our training manual, which will be sent to you after this session. So do refer to those sections if you feel that this isn't detailed enough. So firstly, we're going to look at the legal framework. So to fully understand the EU settlement scheme, it's important to be aware of both EU law and domestic law. Under EU law, the rights of EU, EEA and Swiss citizens and their family members come from something known as the Free Movement Directive. The Free Movement Directive was implemented into domestic law as the Immigration EEA Regulations 2016. As a result of the withdrawal agreement, Appendix EU was implemented into the UK immigration rules. Appendix EU is the legal framework behind the EU settlement scheme. Currently, the EEA regulations and Appendix EU coexist. However, as a result of Brexit, the EEA regulations will be repealed at the end of this year. So, as I'm sure you all know, the EU settlement scheme is a mechanism through which EU, EEA and Swiss citizens and their family members can apply to secure their rights in the UK. There are two key types of status that can be granted under the scheme. Indefinite leave to remain, also known as settled status, for those who have lived in the UK for 5 years or more, and limited leave to remain, also known as pre-settled status, for those who have lived in the UK for less than 5 years. So this next slide shows the different documents issued under the EEA regulations and the EU settlement scheme. It is important that you are aware of the documents issued under the EEA regulations as you may come across people with them in your work. Also, due to Brexit, these documents will no longer be valid after the 31st of December 2020. People with these documents must therefore apply for status under the EU settlement scheme. This table is also provided in the training manual if you want to refer to it after this session. The training manual also gives further and in-depth background to the EEA regulations, which we will not be covering in this introductory part today, so please do refer to it if you want to refresh your memories or learn about it. So now looking at the deadline, the key deadline is the 30th of June 2021. This is what is known as the end of the grace period, and it applies to applicants who are resident in the UK by the end of this year. So that's the 31st of December 2020, which is the end of the transition period. I'm now going to pass over to you, Carla.
Thank you, Bella. Yes, so moving on. Oh, sorry, I need to make myself a presenter. Yeah, okay. So we're going to now discuss about the key requirements for settled status, but we're going to do it quite briefly because we understand that you might be familiar already with this type of application. So the key requirements for settled status are as follows. First, the applicant needs to have 5 years continuous residence in the UK. Secondly, no supervening event has occurred in the applicant's case. And thirdly, the applicant must meet all the eligibility and also the suitability requirements. Continuous residence in the UK means that the person during the 5 years qualifying period cannot be absent from the UK for more than 6 months in any 12-month period of the 5 years qualifying period. Now, this is relevant, especially really relevant for those who have pre-settled status, because after they've been granted pre-settled status, the decision letter will clearly say that they can leave the UK up to 2 years without losing pre-settled status. However, if the intention in the future is to upgrade to settled status, they should always be mindful of the maximum absences that are permitted during the qualifying period, which is 6 months max in any 12-month period. That no supervening event has occurred is a second key requirement under the scheme. Now, a supervening event is defined in Appendix EU as 1. A period of absence from the UK of more than 5 years, or 4 years for Swiss citizens, after the person has acquired the right of permanent residence or have been granted settled status. So 5 years before the person can lose the status for absence. Now, another supervening event is that the applicant has been issued with an exclusion or deportation order under the regulations or under the UK domestic immigration legislation. And then we have as a third key requirement that the applicant must meet all the eligibility, but also the suitability requirements. Now, when we talk about suitability, we need to talk about the suitability assessment that the Home Office carries out in all applications. This means that basically all applicants over the age of 10 years old are going to be subject to a suitability assessment as part of the application process. This assessment is conducted on a case-by-case basis and is based basically on the applicant's personal conduct and circumstances in the UK as well as overseas, including whether they have any relevant criminal convictions and whether they have been open and honest in their application. It's quite relevant, this last requirement of being open and honest in the application, because this essentially means the applicant must be honest in disclosing the criminal records. So, as we just mentioned, criminality features quite heavily in these suitability requirements under the EU settlement scheme. And as I said, so applicants, there is a self-disclosure obligation of criminal records, but this only applies to applicants who are over the age of 18. And the problem of failing to disclose those criminal records when applicants must do so might lead to a potential refusal on grounds of deception, because essentially they haven't been open and honest in the application. Now, in any event, even though the applicant might disclose or might not disclose it, the Home Office will run anyway checks against the Police National Computer, the Warning Index, and also will run overseas criminal record checks against all applicants. The suitability guidance also says that there are some convictions, some activities that don't need to be declared, and those are spent convictions. Again, if the applicant is not sure whether the conviction is spent or not, they might want to check this with a criminal solicitor. Also, warning and cautions don't have to be disclosed as part of the application process, and also alternatives to prosecution. The suitability requirements are considered in Appendix EU15. So EU15 have a list of the mandatory grounds of refusal, and EU16 talks about the discretionary grounds of refusal. We're going to now give you an overview of the application process. It's going to be a very quick overview. Basically, there is 3 checks in all EUSS applications. The first check is the applicant's identity and nationality checking. The second check is the residence checking, which actually is done automatically through the Home Office running checks against applicants' HMRC and DWP records in the UK. And thirdly, the criminality checking, which, as we just said, the applicant must disclose the criminal records, and in any event, the Home Office will anyway check the police national computer against the applicant. Processing times. The latest Home Office guidance on processing times says that it takes around 5 working days for straightforward applications, but it can take up to a month. The guidance also says that processing can take even longer than 1 month if, for example, further information is requested, the applicant is a minor and the application is linked to an adult, paper applications, the applicant has criminal records, or is a non-EA family member, which is applying on the basis of a relationship they never relied before on a previous application to the Home Office. Even though these are the official times as per the guidance, in practice we are seeing delays which are much longer than 6 months. We have seen in our experience delays that can take up to like 12, 13, or even 14 months. If you have a client who is experiencing a long delay and you think it might be unreasonable and unjustified delay in the applicant's case, it might be possible to challenge it via a mechanism called judicial review, and the solicitors that might help you to do this application, they will also first draft to the Home Office a pre-action protocol letter as part of the judicial review proceedings. Now, it's important to understand that not all challenges and not all delays might be challengeable, so it's important to find out whether it is unreasonable in that case for the application to be put on hold or be delayed, and also to look at whether the applicant has suffered a detriment as a result of the delay. It could well be that you might not have the qualification to basically take this kind of cases. If you don't have the qualification, you can always refer to a more senior immigration advisor, and at Careful could sometimes we take on cases involving delays, so you feel free as well to refer to us. Getting a decision. So in most cases, applications get approved. In those cases, applicants will receive a letter by email if they applied using the online application system, or by post if they applied under a paper application form. Now, the letter they will receive or the email, it will clearly state that the letter or the email is not proof of the rights of residence in the UK. So the way to prove your status of settled or pre-settled status is for applicants to view and prove their rights online. And this is because the EU settlement scheme is a whole digital system. Because it's a digital system, the immigration status is linked to the applicant's contact details and information provided when they first apply. That means that the settled or pre-settled status is linked to their phone, to their email, to their address, and also to the passport or ID that they use. It's very important that if any of those details change in the future, the applicant update those details with the Home Office in order to have like an up-to-date immigration status as well, with the information link of the applicant. Now, it could be also sometimes applications are refused. When applications are refused, there are a few remedies. First, for those who applied after Brexit date, so on or after 11 p.m. on the 31st of January 2020, they have now the right of appeal. They can also lodge an administrative review or submit a fresh application at any time before the end of the deadline. Now, for those who applied before Brexit Day, so before the 31st of January 2020, the only remedies available to them is to lodge an administrative review or submit a fresh application. And this is because they do not have a right to reveal in these cases. Losing a status. So settled status can be lost if the applicant lives the UK for more than 5 consecutive years since they were granted indefinite to remain or settled status. And this would be 4 consecutive years for Swiss citizens. And also, and quite importantly, subsequent criminal offending can also lead to a revocation of settled status. For those who've been granted pre-settled status, they are allowed maximum time outside the UK of 2 consecutive years. But be careful again, because as we said earlier, if they want to upgrade the pre-settled status to settled status in the future, if they want to apply in the future, they need to be mindful to respect the permitted absences in each 12-month period of the 5 years qualifying period, which, as we said, the applicant must be at least 6 months in each 12-month period of the 5 years. Pre-settled status can also be lost automatically if it's not converted into settled status before the expiry date of the decision letter. Okay, so now we're going to start talking about the main core topic of this training, which is working with older people and what we can do to support them and what are the issues that they're experiencing when they try to apply under the EU settlement scheme. The common issues that we have identified at Here for Good, and we have had many older clients, is basically, and I would say this is the first and more common issue and the more concerning one, will be digital exclusion. We have encountered as well some technical issues with the application. There is a problem as well of older people that lack mental capacity and how we can help them. Sometimes older people will lack a valid ID to apply and also might lack residence evidence to apply. And in some instances, they might have already been issued with indefinite to remain and they might not know, etc. So these are the kind of 6 common issues that we have identified. In terms of digital exclusion, well, as just explained, the EU settlement scheme is a digital application process. And all the applicants might not feel confident at all using a computer, a phone device, and they might not even have the technology required to do the application or have even access to the internet. Now, we know that the government, to help those who might be digitally excluded, have this assisted digital support via a platform called We Are Digital. This is available, and this support is offered over the phone, face-to-face, and sometimes in local centers or in home tutors. The problem with this service is the applicants are not able to get immigration advice, and it is important that everyone applying for an immigration status gets immigration advice to understand the right of residence in the UK. So it's a very limited, basically, support service. And again, and this is why we're saying here in the slide, it's important to make referral to immigration advisors when the case is complex or when the older person is very vulnerable and needs more assistance and understanding of their rights. Now, older applicants specifically might struggle with accessing online applications. They might not have the resources to scan documents if they need to provide further documentation. They might struggle with completing applications online. They might struggle with setting up and maintaining an email address. They might not have one. They might have never used it before. And they might also struggle understanding how to use this online service in order to access and view and prove their rights to remain in the UK. In those cases, when this happens, there's not much we can do apart from actually explaining to them very clearly that this is a digital system. And you will need to then guide the older person through the application process step by step. You will need to assist them to, first and foremost, set up an email address. A key person that possibly is caring or is supporting them, for example, a family member or a supporter staff member at a residential home, might also be able to help with this. And as much as possible, it will be best if each applicant links their application with their own email address. But sometimes we acknowledge that it's very difficult and they end up linking the application with a family member's family address, which is not ideal because the relationship can break down, etc. But sometimes it's just not possible to do it the other way. And also, you will need to assist them with the scanning their passport or ID through the mobile app and complete the online application, as well as scanning all documents that they wish to provide with the application. After they have received the decision, it's important that you continue helping them, providing them advice, because you need to explain them very clearly that even though now they have applied and they have the status, now they need to understand the most crucial bit, which is how to view and prove that status and how to prove it to third parties, which is important in this case, if they need to prove it to health practitioners or for the benefit agency, etc. So you will also need to inform them very clearly that if any of the contact details change, they need to update their status, which is also quite controversial and might be that some people might forget to do that step in the future unless someone reminds them. And you will also need to print out the letter, the decision letter providing them settled or pre-settled status, together with any of your additional instruction in order for them to understand and have it all printed down and all written down so they know exactly how to then view and prove their status when you are not around helping them. So we normally do like a little step-by-step guide, very simple language, explaining them how to use the email, how to prove their status, and how to keep their status updated. Before moving with to technical issues, with digital exclusion, we have encountered some cases here for good where the older person was so anxious and so stressed about the fact that they had to navigate this online system and that they had to prove their rights of residence in the future using this online digitalized service, that it might be that sometimes it might be best to actually help them to make other applications, for example, under the Windrush Scheme or a no time limit application if they already have indefinite leave to remain but they don't have a card to prove it. This is because under these two other applications, they will actually be given a biometric residence card. And even though it's not ideal because these applications are more complex and you need to provide more evidence than under the EU settlement scheme, it might actually bring a bit of peace of mind to some older applicants who really struggle with this scheme, with the fact that it's digital and they just don't know how they're going to be able to prove it in the future. We're going to cover the Windrush scheme a bit later on, but I just wanted to point out that sometimes you might want to direct them to make other applications if through them they can get a residence card. Now, we have also encountered some technical issues with the application process. I don't know if you have encountered any of these specific technical issue in your work, but basically we have encountered once an applicant over the age of 100 years old. Through the app when we scanned her passport through the app, her Spanish passport, she was recognized as a child when the ID document was scanned. That was because she was born in 1913, but the scanner scanned the document as if she was born in 2013. So she was the process was processing. The application was processing her application as if she was a child and not an adult. So possibly you might have experienced other issues, but this is the technical issue that we have encountered with very elderly people. The solution in that case was basically to call the EU Settlement Resolution Center and then and try and tell them to basically rectify the technical error that we were experiencing. Even though that it became finally solved, and now she has settled status and it's all fine, I have to say that it took us a lot of phone calls for the EU Settlement Resolution Center to solve this issue, and we had really had to push hard for them to do it, and I think we only got it solved after a few months. So yeah, just to point out that we have encountered that technical issue. When calling the Settlement Resolution Center, try to ask for a time frame as to when the issue will be resolved. It might be that they can give you a time frame, but try to keep notes of every time you call them, etc. Because it's important to chase up these applications, because at the end of the day, it's just a technical error. So when calling the Resolution Center, if you encounter a technical issue such the one I explained, ensure, of course, that you have the applicant's details to hand if you want to call them. And you might also need to satisfy the settlement resolution center that you have authority to speak with them about the applicant's application. So you can do so by uploading a letter of authority to the online application, or if you're not acting in that way, if you're just like helping them to find out about when this technical issue will be resolved, you can also call the Home Office together in a conference call with the applicant, and they can also give you, the applicant can also give you authority via the phone whilst during this conference call. Okay, so the third common issue that we encounter with older people is the potentiality that some of them might lack mental capacity. It's not really the purpose of this training to provide you too much information about this, because it's a very complex area of law, but just I want to raise your awareness about some things here in this topic. First of all, what is the law? So the legal framework of those that regulate those who lack mental capacity is found in the Mental Capacity Act 2005. Now, Section 2 and 3 defines a person who lacks mental capacity as a person lacks capacity in relation to a matter if at the material time he or she is unable to make a decision for himself in relation to that matter because of, and this is the important thing, because of an impairment of or a disturbance in the functioning of the mind or brain. Now, it's important to note that having serious mental health issues does not always mean that that person also lacks mental capacity. So that is a case-to-base assessment as to whether the person lacks capacity to understand a specific issue. It might be that someone lacks mental capacity for certain things, but it does not for others. So it's very important that this assessment is carried out correctly. Now, in those cases where you suspect that an applicant that you're helping might lack mental capacity, we suggest that you do the following. First, you need to check if this applicant has already a legal representative that have lasting powers of attorney. You might also explore whether there is any deputy appointed by the Court of Protection to manage his affairs or her affairs, or if someone can maybe act on their behalf as a litigation friend. Now, the EU Settlement Scheme guidance states that, and it's the only thing that states, is that in most cases, the applicant's legal representative should make an application on their behalf. The problem with this statement in the guidance is that it might not always be possible for a solicitor, for a legal representative, to get instructed by someone who lacks mental capacity because they cannot instruct you. So it's quite complex when it comes to the EU Settlement Scheme and those who lack mental capacity. In any event, the person who is acting on behalf of the applicant will need to be satisfied of two things. One, that they have authority to do so, to act on their behalf, and secondly, that they are acting in the best interest of the individual in accordance with the Mental Capacity Act 2005. I would say that the second bit, when it comes to the EU Settlement Scheme, is quite obvious, is in the best interest of those EU nationals or family members to apply under the scheme before the deadline. The problem is how to get that authority to do the application on their behalf. The issues with the EU Settlement Scheme and lack of mental capacity are basically that we don't have a clear policy or procedure published by the Home Office about how to help those who lack mental capacity. As explained, solicitors might be unable to complete applications if they don't have lasting powers of attorney, as they simply cannot get instructed. Independent mental capacity advocates might not have funding to cover these applications. And in most cases, you might need a deputy appointed by the Court of Protection to deal with this application. But this is a very lengthy process. It takes months. And as we know, there is now a deadline, and it's the June 2021. So we don't have that much time anymore to apply under the scheme. I think after been talking for a while, I'm going to pass on to Carla, who is now going to tell you more about those who might lack a valid ID. Thank you.
Great, thank you, Carla. So I'm now going to take you through the next issue, which is lack of valid ID.
So sometimes older people do not hold a valid ID as required by the scheme. For example, often we find their passport has expired, and as they don't travel very often, they haven't renewed it. So the Home Office EU Settlement Scheme Caseworker Guidance accepts that there may be some limited cases where an applicant is unable to obtain an ID due to circumstances beyond their control or other compelling practical or compassionate reasons. Now, in such cases, an applicant must apply using a paper application form and alternative evidence of their identity. It is also worth highlighting that the Home Office EU Settlement Scheme Caseworker Guidance actually provides specific examples that may be relevant to older people unable to provide ID. So these include:
it is impossible or unreasonable for them to obtain or produce valid ID due to a serious medical condition. And in this case, the guidance notes you should provide confirmation of their condition and why it prevents them from having a valid ID from their GP or another medical professional.
So another example the guidance gives is where other factors, such as an applicant's age, although not a serious medical condition, are a barrier to them being able to travel to their home country's embassy or consulate as required in order to obtain a valid ID. So in this case, the guidance notes that you should provide a letter from a GP or other medical professional confirming the barrier of that elderly person to travel. So finally, another potentially relevant example that the guidance gives, which Carla has somewhat referenced to earlier, is where it's impossible or unreasonable for the applicant to obtain or produce the required document because their mental capacity falls under the Mental Capacity Act 2005 or equivalent law in Scotland and Northern Ireland. In this case, the guidance notes you should provide confirmation of their mental capacity and why it prevents them from obtaining or producing the required document, again from their GP or other medical professional. So when you come across an applicant where there isn't a valid ID, we suggest taking the following steps. So these are that you first ensure that all reasonable steps are taken to obtain a valid ID. If it is not possible to obtain a valid ID, you should identify the reason why the applicant is unable to obtain one. You should then assist the applicant to gather alternative evidence of their identity and nationality. You should request a paper application form from the Settlement Resolution Centre, and if possible, you should also prepare detailed legal representations about this issue. So I'm going to take you through each of these steps. And step one is to ensure that all reasonable steps are taken to obtain an applicant a valid ID. Now, there are two reasons why this is important. The first is that where possible, it is preferable for the applicant to have a valid ID, as it will make it easier for them to demonstrate their rights in the long term. So for context, if an EU citizen applies without a valid ID, their digital status granted under the scheme will be connected to a 6-digit application number provided in their acceptance letter. Every time they want to prove their status, they will therefore need to use that 6-digit number on the online system. And in our experience in working with older people, they are often already finding having a digital status very concerning, as Carla discussed, and therefore it's much more practical and reassuring for them to at least have their digital immigration status connected to a physical ID document, such as a passport, rather than this random 6-digit application number. They may also benefit from having a valid ID, as it may facilitate their access to public services or allow them to travel if they want to. Secondly, the other reason is that in cases where no valid ID can be obtained, it's really important to be able to demonstrate to the Home Office that reasonable steps have been taken to try to obtain a valid ID for the applicant, and this is to justify the use of a paper application form and alternative evidence of identity. To ensure that all steps reasonable steps are taken, where the applicant has lost their ID or had it stolen, you should ensure that it is reported to the police and national authority. Where needed, you can assist the elderly person to do this if they haven't already. You should also make inquiries with their embassy or consulate to find out what information, consent, and documents are required to apply for a valid ID, whether it is possible for the applicant to apply for a valid ID from within the UK, and the length of time it will take for the applicant to get their new ID. An important tip is that you should make sure that you keep evidence in the record of all the correspondence and steps that are taken in order to obtain the valid ID, as these may be needed in support of the application. So, step 2. If the applicant has been unable to obtain a valid ID, despite you trying to take steps to obtain one, you should identify the reason this is the case and collate evidence in relation to it. So when doing so, you should bear in mind the Home Office guidance. So as discussed earlier, the reasons they permit include circumstances beyond the applicant's control and compelling and compassionate circumstances. So as noted, there are also specific examples in the Home Office guidance provided in relation to an applicant's medical condition, advanced age preventing them from travelling, and mental capacity. If the applicant's situation falls into one of these examples, you should therefore ensure you provide the evidence that the Home Office guidance suggests in relation to these specific examples, such as the letter from the GP that I mentioned earlier. Then step 3 is to gather alternative evidence of the identity and nationality of the applicant. So the Home Office has a non-exhaustive list of alternative evidence of identity that can be provided. This list is also set out in our training manual that will be given to you after the session. It includes items, as you can see on the slide, such as an expired passport or a UK driving licence. The most common situation we often come across with elderly people is that they have an expired passport. So you should refer to this list and help the older person to gather alternative evidence of their identity. Then step 4 is to request a paper application form from the Settlement Resolution Centre. You do this simply by calling the Settlement Resolution Centre, and you'll need to provide the older person's details when doing so. It's often best to provide your professional address for them to send the paper application form to, or the address that you're working from at the moment. And so then the Settlement Resolution Centre will send the paper application form directly to you, so you can make sure that it's received for the applicant. And finally, in relation to lack of ID, you should prepare legal representations to accompany the application. And these can note the steps that have been taken to obtain a valid ID and the reasons why it was not possible to obtain this, and why alternative evidence of identity should be accepted in the applicant's case. And if possible, you should reference the Home Office guidance and any supporting evidence you have provided to demonstrate the reason the applicant is unable to provide a valid ID. If you feel unable to draft these representations, you could refer the case on to a more senior immigration advisor. So that's the end of lack of valid ID, and I'm now going to take you through the next issue, which is lack of residence evidence. So this is another issue that we commonly come across with older persons. The main way in which the Home Office checks whether an applicant has been resident in the UK is with their automatic checks with HMRC and DWP, as I'm sure you all know. In many cases, the Home Office checks may not be able to confirm an applicant's residence in the UK. It's worth noting that these automatic checks only go back 7 years, and in addition, many older applicants we encounter are only in receipt of a state pension from their national state, and therefore they don't register on the DWP records. It's very important to note that if an applicant has been living in the UK for 5 years or more, you assist them to apply for settled status, not pre-settled status. This is even if you are unable to obtain evidence of their residence for the full 5-year period. It's because settled status is a more secure form of immigration status that may allow an applicant easier access to benefits and public services. This can be life-changing in some situations, particularly when working with vulnerable applicants. So therefore, the steps that we suggest you take with regards to lack of residence are: first, take all possible steps to obtain evidence of residence for the full 5-year period. And then if it's not possible to obtain evidence for the full 5-year period, submit an application for settled status with detailed legal representations regarding the lack of evidence residence issue.
So in relation to step 1, that is obtaining as much evidence of residence as possible, you usually want to check if the older person has a UK bank account. If so, bank statements can be a very easy way to evidence someone's residence in the UK. It is also worth asking the older person if they have registered with a GP or received medical support in the UK, and if so, you can request a letter from their GP or their medical records, again, both of which can serve as evidence of their residence. If the older person is being assisted by an organisation, such as a residential care or nursing home, you can get a letter of support confirming the date they started caring for the older person, or that the older person started living at the nursing home, and that the older person has been continuously resident in the UK since then. Finally, where the older applicant has worked or received benefits over 7 years ago and you are relying on that period of residence, you can request their old HMRC or DWP records directly from those departments. It is worth noting that this is definitely not an exhaustive list. It is just examples of residence evidence we often find useful to obtain in cases involving older people. Also, in terms of a practical tip, it is useful to note that when requesting records on behalf of an older applicant, such as medical records or a letter from their GP, you will need to provide a signed form of authority from the applicant. So, in cases where you have tried but are still unable to obtain evidence of residence for the full 5-year period, you should assist the applicant to apply for settled status and write detailed legal representations in support of their application. These should set out the reasons the applicant is eligible for settled status, the reasons they should be granted settled status despite their lack of residence evidence, any particular compelling circumstances that mean they are unable to obtain evidence of their residence for a certain period, and note any steps that have been taken to try and obtain evidence of residence and the supporting evidence that you are able to provide. It is worth noting here that Here for Good have had several successful cases where we did not have full evidence of the applicant's residence in the UK for the full 5-year period, but we submitted detailed legal representations in support of the application, and the application for settled status was successful. Please therefore make sure you refer on cases to a more senior immigration advisor if you feel unable to write these detailed legal representations and you have a situation where you have a client that is eligible for settled status but you don't have continuous evidence of their residence for the full 5-year period. Okay, so the final issue we are going to discuss is what to do when you come across an older applicant who thinks they already have indefinite leave to remain or indefinite leave to enter granted under the UK immigration rules. So many older persons may have already been issued with indefinite leave to remain or indefinite leave to enter under the UK immigration rules. It is important to note that a person's indefinite leave to remain or indefinite leave to enter issued under domestic law will no longer be valid if it has been revoked on public policy grounds or it has lapsed due to an absence from the UK exceeding 2 years.
So where an older person's indefinite leave to remain or indefinite leave to enter is no longer valid, it's vital that they apply for settled status to secure their immigration status in the UK. It's therefore important that you check with the older person whether their status is valid. In particular, you should ask them if they have had any absences from the UK for a continuous period of 2 years or more. If it is still valid, they aren't required to apply for settled status, but they may still wish to do so for a number of reasons. Now, this side sets out the reasons that elderly applicants with indefinite leave to remain or indefinite leave to enter that is valid still may want to apply for settled status. So this is because if they apply for settled status, they will receive an up-to-date proof of their status. They will have better family reunion rights, in which status under the EU settlement scheme is required. They will be permitted to leave the UK for up to 5 years without losing their indefinite leave to remain status, or 4 years if you're a Swiss citizen. Whereas if you have indefinite leave to remain under the UK immigration rules, as I noted, you lose that status after 2 years of consecutive absence from the UK. And they will also avoid the potential consequences of being unable to easily evidence their right to reside in the future, as we saw with the Windrush generation. So you should therefore inform the elderly person of these benefits and see if they would still like your assistance in applying for settled status, if they have that valid indefinite leave to remain or valid indefinite leave to enter. If you realize that it's not valid, then they absolutely have to apply for settled status. So finally, Carla and I are going to provide you some additional information on British citizenship and other application routes available for older people. We will first raise your awareness of common British citizenship circumstances that arise in older people's cases through looking at naturalisation under 6.1 and 6.2 of the British Nationality Act 1981, and those who are automatically British because they were born in the UK pre the 1st of January 1983. I should note now that British nationality law is extremely complex, and therefore our aim is simply to raise your awareness of when an older person may be able to apply for British citizenship or is already British, so that you can refer them on for more advanced immigration advice. And then Carla will take you through the Windrush application scheme and no time limit applications, as she mentioned earlier. It's worth noting again that teaching you how to do any of these applications would take a whole training session in itself. And so we're just raising your basic awareness of the possibility of British citizenship and also these other application routes. So for many European citizens, the best way to secure their rights to remain in the UK will be to naturalise as a British citizen. Now, this can be done under something called Section 6.1 or Section 6.2 of the British Nationality Act 1981. It's important to note that this may not be the case for everyone because some European countries do not allow dual citizenship, and it can also cause issues with family reunion rights. The application fee for naturalisation as a British citizen is also £1,330, which prevents many people from being able to apply as it's a really extortionate fee. So essentially, the rules for naturalisation under Section 6.1 or Section 6.2 of the British Nationality Act vary depending on whether the applicant is married to a British citizen or not married to a British citizen. So under the current law, the general rule is that if a person is not married to or in a civil partnership with a British citizen, they become a person eligible to apply to naturalise as a British citizen under Section 6.1 once they have lived continuously and lawfully in the United Kingdom for 5 years and they have held indefinite leave to remain or settled status for at least 12 months. If the person is married to or in a civil partnership with a British citizen, they will become eligible to naturalise as a British citizen under Section 6.2 of the British Nationality Act once they have lived continuously and lawfully in the UK for 3 years and have been granted indefinite leave to remain or settled status. So there's no need when you're married or in a civil partnership with a British citizen to wait that 1 year holding the settled status.
So there are a number of other requirements the applicant must meet. These are covered in this slide here. We won't go over all of these now, but you're welcome to refer to this slide or the training manual after this training session. The other requirements are things such as absences limits, a good character requirement, and also there is a knowledge of English language and life in the UK requirement. However, for the purposes of older persons, it's worth noting that those over the age of 65 are actually exempt from that knowledge of English language and life in the UK requirement. As noted, British nationality law is extremely complex, and the Home Office are very strict with the provision of evidence in nationality applications. You therefore should ensure that a person seeks more advanced immigration advice if they do want to naturalise and you do not feel able to advise on this.
You should therefore ensure that a person speaks to a more advanced immigration advisor if they do want to naturalise and you don't feel confident in this area of law. I also just wanted to point out, before we move on, that the Home Office changed their nationality policy guidance earlier this year. With regards to the 5 or 3 year lawful residence criteria, this now notes that for a European citizen to be considered lawfully resident in the UK for that 5 or 3 year period for the purposes of a naturalisation application, they need to have been exercising treaty rights. This term, exercising treaty rights, stems from the EEA regulations and in short means the EEA citizen must have been working, self-employed, studying or self-sufficient with comprehensive sickness insurance. So, if you do happen to be qualified enough to advise on naturalisation applications, you should check that the applicant has been exercising treaty rights in their relevant 5 or 3 year period of residence. With older people, they may think they have been self-sufficient, but it may turn out that they did not hold comprehensive sickness insurance and therefore would not be considered to have been exercising treaty rights for that period. while the Home Office guidance notes that they can exercise discretion in this regard, it is not strictly clear when they will do so. So finally, I just want to raise your awareness on the fact that if an older person was born in the UK before the 1st of January 1983, they are automatically British and can apply directly to the Passport Office for a British passport. There are 2 exceptions to this rule in which the older person will not be automatically British if, when they were born, their father was either a diplomat working for a foreign country or an enemy alien in occupation. The enemy alien in occupation would only apply if the person's father was in the Channel Islands during World War II when they were born, so it's a very rare exception. So definitely, if you come across an older person who was born in the UK before the 1st of January 1983, you should inform them that they may be automatically British and could apply directly to the Passport Office for a British passport. Okay, so that's my brief summary on an overview of naturalisation and British citizenship in relation to older people. And I'm now going to pass you on to Carla, who will take you through the Windrush Scheme and no time limit applications before we move on to the case studies.
So another route that you might want to explore with an older applicant is the possibility that they might want to apply at the Windrush Scheme, as mentioned earlier. Basically, the Windrush Scheme was introduced by the Home Secretary in April 2018 as a result of the so-called Windrush scandal, which mainly affected migrants from the Commonwealth countries, particularly from Caribbean countries, who arrived in the UK before the beginning of immigration controls in 1973. Many of these migrants did not have proof of their legal entitlement to be in the UK, and as a result suffered considerable hardship as a result of then modern government policies, also known as the hostile environment policies. Now, the government finally apologized to people in this position and made a commitment to help them to get the documents they need to prove their residence in the UK through the so-called the Windrush Scheme. Now, the Windrush Scheme applies to different Windrush groups, as stated below. I'm not going to go through all of them, but I just want to point out that Group 2 is the one that would be including any potential EU citizen, because the rest of the groups are referred to Commonwealth citizens. But Group 2 specifically say people of any other nationality, so it could be European, who arrived in the UK and had indefinite leave to remain before 1st of January 1973. So if you encounter an individual who entered the UK before that date, and they might possibly have already been granted indefinite leave to remain, so you might then want to explore the potentiality of putting a Windrush Scheme application. In this slide, I'm kind of saying the same. So as you will notice, all the European citizens, despite not being Commonwealth, are covered by Group 2 and 3 also above. I'm just going to go back 3. 3 is also, I was forgetting Group 3, but actually is for those people of any nationality who arrived in the UK between January 73 and December 88, who also have indefinite to remain. So look at this Group 2 and 3, and possibly some applicants might fall under those groups. So in those cases, if they fall, they might then be able to apply for a biometric residence permit under the Windrush Scheme. This might be preferable for some older persons because they might want to get a physical document. They might not be happy with the digitalization of the EU settlement scheme. So through that, you might want to get them a physical document. Like the EU settlement scheme, the Windrush Scheme is also free. And for more information about how to complete an application and what documents to provide in support of it, you should look at the detailed guidance. I would also like to say, when it comes to having a proof of your residence in the UK, that even though this might be attractive, it might be that it's also pointless in the near future, because it seems that the Home Office tendency or intention is to possibly digitalize all immigration status. But for the time being, under the Windrush Scheme, they can get a biometric residence permit. The other way to get also a biometric residence permit is by submitting what is called a no time limit application. Now, even older European citizens have a valid indefinite leave to remain, valid because it has not been expired for more than 2 years absence, etc. And this person is not eligible for the Windrush Scheme. They would prefer to get an up-to-date proof of their residence right, because the old indefinite leave to remain might be stamped in a passport, in an old passport, or it might be a very old letter issued by the Home Office. So the way to digitalize, basically, to have an up-to-date proof of status from this stamp in the passport or this letter to the Home Office to actually a residence card is by putting a no time limit application. So basically, as explained in the slide, this is an application process which allows those who already have indefinite to remain to transfer that right to a up-to-date biometric residence permit. The problem with no time limit applications, though, is that they are not free. They cost £229. So there might be some applicants that might be prevented from applying for financial reasons as well. And again, more information about how to submit a no time limit application can be found in the Home Office guidance. Okay, so we have now finished our training for today. What we're going to do now, we're going to now have a break, 5 minutes break, and then we're going to go through some case studies, and then we're going to have a Q&A at the end of the session. So I'm just going to introduce these case studies. So we're going to see the first one. We're going to give you some facts and initial questions. I hope you all can see the slide. So we're just going to give you like a couple of minutes for you to check the facts of the case, and then to try to answer the initial questions, and then we take you through the case. So yeah, just a couple of minutes. Bella, do you want to summarize the facts, or do you want me to do it? This I can't remember.
Yeah, we can do them together, Carla, but I'm happy to summarize the facts, so it's fine.
Great. Yeah.
Great. So here we have Maria, who is a Greek citizen, and she's aged 103 years old. She moved to the UK over 20 years ago so that her son, who was living here, could take care of her. She doesn't have any suitability issues. Maria is self-sufficient, and she receives a state pension from Greece. She has been registered with her local GP since 2002. She also has her own bank account in the UK. However, other documents relating to her address, such as utility bills and mortgage statements, are in her son's name. Maria has a valid Greek passport, but has never travelled outside the UK since arriving here in the late 1990s. We know that she's not computer literate. So she has received help from her son to use the EU Exit ID document check app to scan her Greek biometric passport, but her document was incorrectly scanned as the app registered her date of birth as a child. So due to her situation, Maria is also concerned about the lack of residence evidence she has. the Home Office automatic checks with HMRC and DWP did not register her residence in the UK, Maria and her son have come to your organisation for assistance with her EU settlement scheme application. So the initial questions, as you can see posed on the slide, are: is Maria eligible for settled status? And identify the key issues present in this scenario. So if anyone wants to answer these, they can unmute themselves or write in the chat. So Ludmila has said yes, settled status. That is correct. So Carla, if you want to take us through the slides, I think you're still presenter.
Sorry. Yes. So yeah.
So Maria may be eligible for settled status because she has lived in the UK for a continuous period of at least 5 years. She meets the eligibility and suitability requirements, and no supervening event has occurred in her case. So then the next question that we're going to look at is what issues you see in the scenario that may affect Maria's ability to make an application. So Carla's put the scenario in front of you again. If anyone wants to either comment in the chat or they can also speak, you're very welcome to speak as well if you want to unmute yourself. So what difficulties will Maria face when she's trying to apply? Yeah, so again, Ludmila has said technical issue that is age-related, and that's correct. So Carla, do you want to go through this one?
Yes. Sorry, this is the technical issue.
Yeah.
Sorry, do you want me to explain? So
yeah, as you want.
Sorry. So yes, this is exactly what happened to us, this technical issue, and I was explaining before when I was doing the presentation. Yes, the age has been registered wrongly under the ID document check mobile app. So in this case, we will just need to call the resolution center and try for them to change it, because it's a technical issue. They should solve it. And of course, you should also try to follow up with them if you don't get any response in a few days, and also ensure that you get some sort of like time frame regarding when the issue will be resolved, so that you can then inform Maria in this case. So technical issue was one, and there's two more issues that you can encounter in this type of a scenario. Does anyone else want to say anything? Otherwise, we're just gonna go. I'm gonna cover them myself. Okay, so another issue that Maria will face is this one, digital exclusion. So Maria seems to be a very old person, and she doesn't really know how. She's not in the fact the scenario we had that she's not computer literate. So Maria will need guide to go through the application process, and more importantly, once settled status is obtained in this case, Maria will need, of course, information and clear instructions as to how to access and prove her status in the future. In this case, her son is around, her son can help her, so that would be like information that you will also need to provide to the son so that he knows how to help his mother in this case. And yeah, as examples, like you will provide them with Home Office decision letter, and you maybe will draft a small step-by-step guide on how Maria can prove her right of residence in the UK and how to update her personal details when applicable in the future. And there's one more issue, which is, this one.
Yeah, great. So I think the other issue is not necessarily an issue which you may have noticed, but Maria has concerns regarding her lack of residence evidence. However, there is no need for her to be concerned. So, from the scenario, we know that Maria has been registered with her local GP since 2002 and has had a UK bank account. So Maria could therefore obtain her medical records or a letter from her GP that confirms when she registered with them, her UK address, and any appointments she has had. It's worth noting that if you want to request these records directly, you'll need a form of authority. You could also see if Maria can request her annual bank statements for the past 5 years from her UK bank. If she does not have online banking, her son may be able to go into the local branch and request that these are printed. We'll go on to the next case study now. So we'll give you about a few minutes again to read through this, and then we'll go through the case study together. Okay, Carla, do you want to provide a brief summary of the facts?
Yes, sure. So in this case, we have a dual national, Philip, dual national from France and Turkey. He is also an older person. He's 82 years old, and he first moved in the UK in the 80s. During this period, he was granted indefinite leave to remain, but then in 1994, he then left the UK and returned back and lived in France for 14 years. He returned back to the UK in 2008 when he was 70 years old. He has lived continuously here since then, since 2008. Philip first stayed with his friend Alex, but for the past 6 years, he has been living in a nursing home. He's also financially supported by his son, Alex. Philip doesn't have a bank account, and he has never received any bills, any council tax, has not applied for benefits, has worked, or has not received any benefits, and UK pension, sorry. Now, due to mobility issues and his old age, Philip has not left the UK for the past 7 years. His French passport is now expired, but he still has a passport. He has a Turkish passport. Philip does not have any criminal or suitability issues that we should be concerned. Now, Philip has poor vision and has recently had an operation. And in 2018, he was diagnosed with Alzheimer's. So because of that, because of his health has deteriorated, Alex, his son, has now applied and been granted a lasting power of attorney. Now, Alex is, of course, concerned about his father's status in the UK in light of Brexit, and you now have been asked to help them to make the application. So, Mariana, I can see already that Mariana has said to the first question that he has already indefinite leave to remain. So that is right. So in the fact, it does say that he was granted indefinite leave to remain. Exactly, as Alexandra is saying now. I was waiting if someone was about to say it, that lapse. So indefinite leave to remain granted under the domestic legislation, not under the EU settlement scheme, lapses for absences of more than 2 years. So in this case, for sure, it has lapsed because we know that Philip left the UK and lived in France for 14 years. So that indefinite to remain is not valid anymore. In any case, Alexandra, or maybe someone else wants to say it, is he eligible for settled status in any event, do you think, or not? Yes. So it's clear in this scenario that yes, because he's been in the UK since 2008, and nothing indicates that he has left the UK, and in fact, he has not left the UK for the last 7 years. So to the first question, it's quite clear. I think that would be yes. So here we just covered, this slide just covered what I said. And he is granted for settled status because of the reasons that we know. He lived in the UK since 2008, meets all the eligibility requirements, and no supervening event has occurred. Now, well, you just saw that, sorry, I went a bit too fast. But anyway, so these are the key issues in this scenario. I don't know if any of you have spotted them or if you even think that there's more than that, but these are the main issues that we had to deal in the case of Philip. So potential lack of mental capacity. He said that the French passport is basically expired, and residence evidence. Does anyone, can Philip apply with the Turkish passport? Do you know if that is possible? Because that happens sometimes. With dual nationals, we get this question quite often. Can I use my Turkish passport in this case to apply under the EU settlement scheme? Does anyone know? Okay, so no responses, but in this case, the answer is no. So because he is relying on the fact that he's an EU national from France, that is the nationality that he is using for the application, and not this other nationality, which is a non-EU nationality. So, okay, so to cover the key facts, lack of mental capacity, we already know by looking at the facts of the case that he has Alzheimer's, and because of that, he gave, and his son is now granted a lasting power of attorney. So you should then, that should satisfy you that his son has capacity and authorization to act for Philips in this application. In any case, if you are helping them to do this application, you should ask to see a copy of this power of attorney. Once you have confirmed that it's true that Alex has lasting powers of attorney, then you can take instructions directly from Alex if Philip is unable to instruct you. Alex can then apply on Philip's behalf, and therefore you can go through the application questions with Alex. And of course, you should submit a copy of the lasting power of attorney to the Home Office as evidence that he is acting on his behalf in the application. Mariana said, please leave the scenario first page to see it. Yeah, I can leave it here if you want. So that was the issues. Now, the other issue that we have just covered is the possibility of, the fact that he lacks ID. As explained in the facts here, he only has a Turkish passport. So I'm just going to leave the slide here because it might be easier instead of going through the steps. But in terms of no valid ID, Bella earlier on already covered this when she explained about what to do when someone lacks valid ID. Basically, you should do all your steps to try to obtain for him a new passport. So you will contact the French embassy consulate and then try to liaise with them to get one. If this is not possible, you might need to identify the reasons why it's not possible to get an ID. Gather all the evidence possible that supports the fact that he cannot get a new ID, and then and submit a paper application form. Now, you might want to refer to the fact that he lacks mental capacity as another reason why he is unable to obtain an ID. You can gather alternative evidence of his identity. He might have, in this case, it's clear he has an expired passport, so you would need to submit this expired passport as proof of his identity. But because it's expired and it's not valid, you cannot apply via the online system, but you will need to request a paper application form and apply through that route. And again, if you're helping them directly, you might also want to draft legal representations explaining basically what happened in the case and his entitlement to settled status and the reasons why he's applying without a valid passport if he is unable to obtain one. The other issue, and I'm keeping these slides again, just might be easier for you to see, is a lack of residence evidence. So looking at the facts, we know that he's been here since 2008. The problem is he's always been supported by his son, and since the last 7 years, he's been living in a nursing home. Because of that, he doesn't have any council or utility bill or council tax under his name, and he has never applied for documents, etc. So Mariana is asking, in this case, which documents Philip needs for the application? This is a very good question because it seems that we don't have bills, we don't have benefit records, we don't have working records or UK pension. So what documents do you think, if any of you might want to throw some ideas as to what documents should be useful? Great. So Alexandra just said a very useful tip, which is, of course, a letter from the nursing home. So the nursing home can easily confirm in a letter that this person has been resident there for the last 7 years.
Yeah, exactly. We know that he's been there, for the past 6 years, so we can get there.
I keep saying 7 years, it's 6 years. And also medical records, as Alexandra is saying. So if he has some medical records, that would be great to obtain, talk to the GP. Can be medical, GP, exactly. We know that he has Alzheimer's, isn't it? So he might have been diagnosed of this by a GP or by any other medical practitioner. As well, he had an operation in 2017, so there will be records of this operation for cataracts in 2017. So medical evidence would be very useful in this case. I think we're not leaving anything now. I think that would be most of the evidence that we will basically try to gather. And just going forward the slides a bit, okay, Bella, I think you are the presenter still. But I just wanted to remind everyone, one more here. I just want to remind everyone that even if you are unable to obtain those letters that Alexandra, Mariana, etc. have been saying, even if you are unable, please do not apply for pre-settled status, because it's going to be much easier for him to be granted settled status for his life. He's going to be able to access positive benefits, etc. So if unable to obtain those documents, try to explain why you are unable in a covering letter. We've done this before with many applicants, and we actually have been successful. So in the letter, you should set out Philip's circumstances, why he's eligible for settled status, which evidence you're providing, and also the reasons why he should be granted settled status despite of this lack of residence evidence. In this case, in practice, you shouldn't have problems because you have the nursing home, but in other cases, you might not have a nursing home and you might not have that this type of a scenario.
Okay, so that's the end of our training for today. We are now going to move on to a Q&A for those of you who are watching live. For those of you who are viewing this recording at home, thank you very much for watching our webinar. We hope that you found it useful. Please feel free to refer to our detailed training manual if you want to look back at the written solutions to the case studies or refresh your memory on anything you have learned today. Thank you very much and goodbye.
Goodbye, everyone.